All right, everybody. Thank you for coming along to this webinar. Let's get started. My name is Anton Blijlevens. I'm a principal here at AJ Park, and I work here in the Auckland office. First of all, we'll just do a little bit of housekeeping. So this webinar is interactive, which means that you can ask questions. The questions you'll need to type into the Zoom app, and they'll appear on my screen. And then I'll answer the questions. Some of the questions I may defer until later because it may be that some of my slides are going to cover the questions that are being asked. But I'll check for questions probably at the end of every slide and see whether to answer them then or later. Also, some of you might have registered for CPD points. I know that some of you are lawyers in private practice or working in-house. At the end of this week, we'll send you CPD certificates. If you haven't indicated that you want CPD certificate sent to you, then please email marketing@ajpark.com and we'll put you on the list. Okay, so just a little bit about myself. So I'm Anton. I've been at AJ Park for 25 years now. I work in the mechanical engineering patents team. It's because I'm a graduate from Canterbury with a mechanical engineering degree. And then I did law here at Auckland University. So I work with a lot of large and small New Zealand companies to protect their IP rights in Australia, New Zealand, and all around the world. I do a bit of lecturing at the university and also for the World Intellectual Property Office. And I run the China desk here at AJ Park, which is an initiative we started probably about 8 years ago. When we found that more and more of our clients were doing business in China. So we're helping them with their IP protection in China. Quite a few of you will be well aware of AJ Park. We've been around for 127 odd years, have offices in Auckland and Wellington, clients not just in New Zealand, but from all around the world. So we have about 7,000 odd clients. And we don't just do IP protection in New Zealand and Australia, but all around the world. So we're active with IP protection in around about 150 odd countries. In our patents team in particular, we've got lots of capability in different areas of technology. I'm told that there's 60 areas of technology that we have specialists in. Okay. So I know that most of you are in-house lawyers or in private practice. Some of you may not be, but this webinar has been designed to help you deal with initial inquiries that you might get from your clients or from people within the business. It's to help you understand more about patents and registered designs, as these are the most common form of IP protection for products. So I'll take you through the differences between patent and design protection. We'll talk about what an innovation needs to have to qualify for legal protection. We'll talk about what the pros and cons are of patent and design protection, and what steps are involved to secure patent and registered design protection. And we'll also talk about what other things you need to cover off, such as infringement risks and ownership, and a few other points. So steps or points 1, 2, 3, and 5 are effectively the process that you would go through in deciding on the right type of intellectual property when it comes to patents and designs. It's kind of like a filtration process. In the presentation, you will hear some practical examples, cases that we've been involved with, such as with Air New Zealand for their Sky Couch and Zuru bunch of balloons, a very popular kids' toy product. So they say that intangible assets of many companies are worth more than all of their tangible assets combined. You will have heard that Uber is the most valuable taxi company, but it doesn't actually own any taxis. You've heard that Airbnb is the most valuable business hotel service provider, but it actually doesn't own any properties. Okay. So you can see that intellectual property and intangible assets can make up a substantial part of the value of a business. So ensuring that innovations are protected appropriately can create and protect a lot of value in a business. Patents, copyright, trademarks, registered designs all provide different types of intellectual property rights that can be used to protect new initiatives and new innovations. It's important to understand the role that intellectual property can play within a business. A lot of our clients seek intellectual property protection to stop people from copying them. So that's usually the primary motivation for protecting innovations. But IP rights can also help build value in a new initiative. It can create licensing opportunities or sale opportunities. I think this time last year, Power by Proxy, a New Zealand tech company, sold to Apple for more than 100 million New Zealand dollars. And Apple purchased them primarily because of their intellectual property rights that they had. I think they have over 150 patent families for various bits of their technology. Intellectual property rights can help create access to industry standards organizations, attract investment and funding, and help with collaboration with others. And so why would you bother? Well, businesses have many different reasons for doing this, but primarily it can create a competitive advantage, increase in revenue, increase value, and support more R&D. And for businesses, they all have different motivations for protecting their IP rights. So it's important to know what preliminary steps need to be taken to help ensure that IP rights of the right type are available to protect innovations. It's important to know the conversations you need to have with the creators of the IP. And those sorts of things we'll cover later on in the webinar. So intellectual property is a general term that's used to describe different rights that exist under different areas of law. So patents, trademarks, registered designs, and plant variety rights are common forms of intellectual property right that require for you to go to a patent office and go through a registration process in order to protect the initiatives that fall within those IP rights. There's also trade secrets and confidential information and copyright. And they come about automatically. There's no registration process required. They come about through contract or through conduct or a mixture of both. So intellectual property is a very international body of law, and at a very high level, it's very much the same in most countries of the world. So what you'll learn today will have a primary focus on New Zealand patent and design law. You will learn things that will have application in other parts of the world as well. In fact, most of the, well, I think probably 50% of the work that we do at AJ Park is to help protect innovations and brands for New Zealand clients in other markets, so in other parts of the world. So we're very familiar with US patent law, Chinese trademark law, European patent and design law, etc. New Zealand ranks at about number 20 in the world where companies are filing patents. On a per capita basis, it's quite an expensive country to get patent protection. You're talking between 5,000 to 10,000 New Zealand dollars, whereas in the States, with a much larger population, you might be talking between $10,000 and $20,000 to get a patent. In fact, around about 95% of all patents filed at the New Zealand Patent Office are owned by foreign companies. It's around about 50% for trademarks and registered designs. I'll just have a quick look at some questions that might have popped up. Okay, so one question that's been asked is plant variety rights. Can you please explain about those? It's a pretty unusual area of intellectual property law, but it's protection for plant varieties. Relatively popular in New Zealand, but in other parts of the world, there's not a lot of research and development going into plant variety rights. Okay, so let's look briefly at the different categories of IP rights before we delve further into patents and registered designs. So trademarks provide protection for brands, maybe in the form of a logo, in the form of a product name, a company name. Trademarks, unlike most other forms of intellectual property right, can last forever. All the other forms of intellectual property rights, other than potentially trade secrets, have an expiry date. So trademarks can be very valuable. They say that if Coca-Cola were to relinquish their trademark protection, the loss would not be as great to Coca-Cola if all of their tangible assets were destroyed. So if they were to hand over their Coca-Cola trademark to their competitor, it would hurt more than if all of their stock, their factories, their trucks were destroyed. So I'm told. Okay, some other categories of intellectual property rights include patents. So these protect inventions, and they can reside in the form of, they can exist in the form of products or processes. An example that we'll come to in a minute is the New Zealand Sky Couch. A patent can provide a monopoly right for the concept that exists in a product, so the invention that resides in a product, and can last for 20 years. Registered designs is protection for the shape or appearance of a product or part of a product. So it's much narrower protection, but can still be really important to have. Copyright is another form of intellectual property right that can stop the unauthorized copying of such things as original drawings, software, music and film, books, texts. There's no registration required. In most countries, there is no registration process. It comes about automatically. One of the difficulties in proving copyright infringement is that you need to show that copying has occurred. So if someone creates a novel or takes a photo of the same thing as you have, but hasn't actually copied your copyright work, then there's no copyright infringement. It's been independently created. And the last category on the screen is about confidential information and trade secrets. Most new initiatives, well, all new initiatives start life off as a trade secret. So it's important at a very early stage in the development of a new product or process or new initiative to determine whether trade secret protection is going to remain appropriate or whether other forms of intellectual property rights are better suited to protect the business. Some products are eligible for multiple forms of intellectual property protection. And so here is an example. So I've taken the Coca-Cola bottle. At some stage, the crimped lid, the metal lid, was patented back in the 1800s. So that had patent protection for a while. The brand Coca-Cola obviously is a very well-known form of intellectual property protection in the form of trademarks. It'll have the domain name protection. The label, so the logo, copyright protection and trademark protection. The shape of the bottle at some stage may have been eligible for registered design protection, in some countries copyright protection, and in some countries it's been protected by way of a shape trademark. Okay? And then also the contents of the Coca-Cola bottle. So that's a trade secret. So Coca-Cola have decided to keep that as confidential information, trade secrets. So what are the differences between patent protection and design protection? So there are some really headline distinctions that we should cut to straight away between patents and designs. So registered designs is protection for the shape or the appearance of a product or part of a product. Okay, whereas patents protect a product or process, and it protects the concept that resides in the product or process. So patents is protection for an invention, might be a bionic eye, a virtual reality tool, a self-driving car, 3D printers, and it's protection for the concept that resides in the product. Whereas registered designs is protection for the appearance. So I've got an example here. This is an ice cube container. It's an enclosed ice cube container, so that when you're transferring this from the tap to the fridge, you're not going to spill water. The registered design protection for this was for the rectangular shape of the product with the dimples in the bottom, whereas the patent was for the concept of an enclosed ice cube container, irrespective of whether it was round, rectangular, or square in shape, and irrespective of the number of dimples in the bottom. It's a good example of the difference between patents and registered designs applied to that particular product. So when a client comes to see us for protecting a new innovation, we'll ask them, well, how different is your innovation compared to what's been done before? Because that's one of the requirements for both patents and registered designs. And they'll tell us, well, I know about a product that's old. It's been out for a little while. It's the unicycle, but I've made an improvement to that product. And I've invented the bicycle. Okay. So that's the product that the client comes to see us with, and they want to get protection for that. If we're going to look at patent protection, we need to conceptualize what the bicycle is about. Sure, we can file a patent for the product, but the protection is quite narrow. So when we talk to inventors, we try and figure out, oh, what is the concept that resides in the invention? And it may be that alternative two-wheeled or multiple-wheeled vehicles are solving the same problem that the unicycle has. So perhaps a tricycle is another form of product that should be captured by the patent. And it may be that the concept also extends to scooters. Okay, and so the patent that we might file and the invention that resides around the product might be much broader than the product itself. So patents can be filed not just for products, but also for processes. Software, for example, is effectively an algorithm, which is a process. It's a method of doing something. Probably the most famous, well, the one that I find the most famous patent for software is the Amazon one-click ordering invention. But patents are filed for mechanical devices, electronic devices, chemical formulations, manufacturing processes, and also with more difficulty or with some exceptions in some countries for DNA, modified plants and animals, medical treatment, and computer software. Some other famous software or method patents that exist out there include Dropbox, Uber, got quite a number of patents for their system, and Airbnb. So registered designs can only protect the shape of a product or part of a product. The pattern on a product, such as on wall cladding or fabric. So the registered design cannot protect a process, nor can it protect the concept in a product. So this is quite a useful filter if a client comes to see you with an invention that is software, or that's an electrical system, or a chemical process. Then you're not thinking about registered designs, you're more thinking about, well, is a patent going to be applicable? So the example that's on the screen here is the Air New Zealand Sky Couch. And this is an example of where we protected, by way of a registered design, the shape of part of the product. So the protection is for the bits in yellow, which is the seat pan and the leg rests in a row of 3 seats. So the registered design for the Sky Couch here was stopping anyone from making a product that looked the same in respect of the seat pan and leg rest. If a competitor came along and made a row of 3 seats that had a different back rest or armrests, but had the same seat pan and leg rest configuration, then the registered design could have stopped that. Okay, I think we might have some more questions. Okay, so the question is, what is the longest time it has taken AJ Park to secure a patent for a client? Is it based on the complexity? That's an interesting question. Sometimes it's a good strategy to delay a patent being granted for as long as possible. In some countries, the patent process actually takes a long time, like in Malaysia and Indonesia at the moment. and in Thailand, it can take up to 10 to 15 years for a patent application to go through the examination process. But for some of the clients that I've worked with, including for Zuru, for example, with the product bunch of balloons, we managed to accelerate the patent granting process in quite a number of countries. And we may have been talking between 6 to 12 months in some countries. So it can really depend on the country and on the strategy. Okay, one more question. Okay, so I've mentioned before that software can be covered by copyright. And so the question is, in what instance would you also need to file a patent? Okay, so when it comes to protecting software by way of copyright, it is protection for the actual text, the code that is written down. And so it's quite narrow protection. It effectively just stops someone from copying that source code. And then copyright is really effective. But a patent can stop the concept in the software from being copied. So the one-click ordering of Amazon, it could have been written in different software languages. The algorithm could have been structured quite differently. Copyright would have stopped the copying of the exact source code. The patent would have stopped copying the concept. All right, we'll carry on to the next slide. There's a few more questions coming in, which is great, so keep them coming. So here's some examples of New Zealand registered designs. There's the jug by Air New Zealand that you'll see on many Air New Zealand flights that they use to serve hot beverages. Okay, there's a Sistema lunchbox container. There's an example of a pattern that's protected here in New Zealand. And there's also an example of an extrusion. In New Zealand, there's around about 1,300 registered designs filed each year, compared to about 7,000 patents, which is really insignificant compared to the likes of the United States, where there's probably about 600,000 patents filed every year. In China, there's about 1.3 million patents filed every year. In New Zealand, I think a lot of registered designs are filed for consumer products, like you see on the screen, for packaging and for building products, building technology. So here's a quick summary of comparing patents and registered design protection. Both patents and registered designs will result in publication eventually by the Patent Office. Patents provide wide protection to the extent that the innovation is new, whereas registered designs is quite narrow protection. It's protection for the appearance. The term for a patent in most countries is 20 years. For registered designs in New Zealand, it's 15 years, but depending on the country, it could be up to 25 years. The cost of patents is relatively high compared to registered designs, and the process can be quite slow compared to registered designs. So often for products, and this is an example here, which is the Zuru bunch of balloons. This product has been copied by a number of people. And for their product, we filed registered designs to get very quick protection to prevent direct knockoffs. And we filed patents to protect the concept in the product. So irrespective of the shape. And the patents came in behind after the registered designs were registered to provide an extra layer of protection and strong protection. So what does an innovation need to qualify for patent and registered design protection? Okay, so once you've established what type of IP right is inherently applicable, there are a few more steps that you need to take to determine if an IP right in the form of patents and designs is actually available or really applicable. So let's look at each of those patents and designs in turn. So what is patentable? So innovations that are new and not obvious are patentable, but there are some inherent exclusions or things that are specifically excluded from protection. So we've heard already that logos, brands, music, film, those things are best protected by way of copyright, and trademarks. Things that can be patented are discoveries, so things that are, for example, already happening in nature, and you've merely discovered that a particular process occurs or a particular plant has some benefits. You can't patent that plant or that tree. It's a discovery. Sometimes mathematical formulas that explain concepts in nature or physical concepts are developed, but they are merely explaining what's already happening. So it's a discovery and therefore can't be protected. Methods of medical treatment of humans in most countries, I think all countries, cannot be patented. And in some countries, software and business methods are really difficult to get patent protection for. But if there's some form of technology used to implement those last three things, then there's potentially a good prospect of getting protection for the technology that's used. So I mentioned before that for patents, an invention needs to be new and not obvious. A first question to ask an inventor when they come to see you and say, hey, I want to get some protection for my invention or my product, is ask them, have you kept this confidential? Okay, so it's really important that new innovations are kept confidential until a decision is made about what kind of intellectual property protection to pursue. And if it's patents or registered designs, then the patent or design application needs to be filed before the invention is commercially used or disclosed. Okay, this is really important. So if an inventor or the business needs to have input to develop the product from external, then use confidentiality agreements, non-disclosure agreements. That brings the people that are helping you with the development into the cone of silence, and it keeps the invention secret effectively. There are some exceptions to this rule. Experimentation, if it needs to be done in public, in some countries that can be excluded, so that could be okay. But if you're going to rely on this, then it's important to get some specific advice around what you can and can't do in terms of experimentation. Some inventions need to be trialed in public. Drone taxis, large-scale irrigation products are examples that you can't keep indoors to trial and test them. But again, if you're going to rely on that, be careful. Get some specific advice. And there's also grace period countries. So in some countries, an inventor or the company that owns the invention can commercialize or publish the invention up to 12 months before a patent application is filed in those countries. So the United States and Australia are examples. So if the inventor said, well, I've actually put the product on the market about 2 months ago, you can't get a patent for it in New Zealand, but you may still be able to get a patent for it in some countries like Australia, the United States, and a handful of other countries. So the golden rule for patent protection and for registered design protection is to keep the invention confidential and non-commercial until a patent application has been filed. Okay, we'll have a quick look at another question. Okay, so the question is, what would the rationale be to delay getting a patent awarded? Okay, so that's a really good question. Sometimes it's a matter of cost. So the examination process that we'll illustrate in a minute can be reasonably expensive. And so delaying a patent going through that examination process can delay the cost of that exercise. Also, whilst a patent is pending, it means that the scope of protection has some degree of flexibility. And so it may be that further iterations of the bicycle are developed, a skateboard might be developed, and it may be that the patent is set up to protect a four-wheeled vehicle. And increasing the scope of protection of a patent application whilst it's pending is a lot easier than after the patent has been granted. Once the patent's been granted, its scope of protection is pretty much set in concrete, so you can't change it a lot. Okay. All right, so it's also really important to understand, well, what is different about the invention compared to the disclosures of others. And so we call this prior art, prior publications or prior use anywhere in the world can have an impact on the scope of protection that an invention can get. Okay, and that's why it's really important before you go down the path of filing a patent to conduct some prior art searching. So here's an example. Client comes to you with a product. We do some searching to determine what the prior art looks like. Okay, so we find out what the prior art looks like, and then we can draft a patent whose scope of protection is really broad, but avoids the prior art at the same time. Okay, so searching is really important before you go down the path of filing patents. It may be that you find that the broad concept is not available. It may be that the bicycle is already old, someone has published it beforehand, but you may be entitled to protecting the shock absorbers on the bicycle, which may also be useful for unicycles. So knowing about the scope of protection you're entitled to is really important. And we did that with the Sky Couch with Air New Zealand. So Air New Zealand had about 5 or 6 options available for innovating seating in economy class, and through a filtration process, through determining what regulatory requirements existed, technical feasibility studies, but also understanding what the patent landscape looked like, was an important part of the process for New Zealand to boil the innovations down to what ended up being the Sky Couch. So New Zealand was really keen on licensing this technology to airlines that didn't compete with them, and having intellectual property protection in place was an important factor in the decision process. And so they've now licensed the Sky Couch to a number of other airlines around the world. Okay, so for registered designs, in order to be eligible for protection, the product or part of the product needs to be new and original. So it's about the shape, not about the function. And so sometimes inventions or products that clients come to see us about are not inventive. They're obvious compared to what's been done before, but they may have a particular shape that's important to protect. And so then we look for registered design protection for the shape of the product. Okay. Products that are purely functional cannot be registered as registered designs. I mentioned before grace period countries for patents. Some of the countries around the world also have grace period for registered designs, and it's usually a 6-month period from first use or publication that you need to file in those countries. So what are some of the pros and cons of patent and registered design protection? Okay, so you've seen part of the slide already. I've introduced trade secrets as well because it's relevant to the decision about filing patents. But let's talk about designs first. So designs are cheap and quick to get. In New Zealand, you might be looking at around about $1,300 to secure a registered design, and it should take between 3 to 6 months. For all of Europe, a registered design might cost between 5,000 to 6,000 New Zealand dollars. So as I mentioned, a common strategy is to file registered designs to protect the appearance of a product, to help stop competitors making knockoff counterfeit products that look the same. And whilst that protection is in place, the patent application is going through its examination process and subsequently will be granted to protect the concept and thereby stop competitors from making products that might look different but do the same thing. Okay, so protecting the concept. The downside of registered design protection is that it is limited in scope. It is protection for the appearance. So for the rectangular ice cube container, the protection is for the rectangular shape with dimples, a closed top, and a large spout. Okay, it's limited to that. There is a little bit of leeway available. It doesn't have to be a direct copy for it to be an infringement of a registered design, but the scope of protection of a registered design is really dependent on how original the shape of the product is in the first place. So if the product shape is 80% different to what's been done before, then it may require for a competitor to make an 80% change to the shape of the product, just to give it some numbers and context. There are no hard and fast percentage rules here, but it's just to illustrate what I'm meaning. But if the product is only 5% different in shape, then the scope of protection is only 5%, meaning that a competitor can make a 6% change and avoid the protection. Okay, for patents, the pro of a patent is that it's protection for the concept. Okay, the term of protection is 20 years. It's quite a long time for some products, but for other products, particularly in the pharmaceutical space, by the time that approval has been obtained to launch the product, there may only be 5 years left in patent protection. So for some products, the term is very short. So some clients use patent protection to stop others from copying. Some clients of ours use patent protection to license the IP. They're not geared up necessarily to be able to take the world by storm in terms of manufacturing and distribution, and they may find someone else that is better placed to do that, and they may license their IP rights to much larger organizations that can capitalize on the IP. And some of our clients are filing IP protection, patents for technology, to help secure investment or to create an exit strategy. Some of the downsides of patent protection is that it's going to result in publication of the invention. And so this is where the trade secret column comes in. If your invention is able to be kept as a trade secret for long enough, then you need to consider whether patents or trade secrets are the best form of protection for the invention. So Coca-Cola have managed to keep their formulation as a trade secret. The only cost to the business is to keep that invention secret, that formulation and that process secret. Okay, so that can be quite a costly exercise, and it's also very risky because if the technology is leaked, or if someone else independently develops the same formulation, then the trade secret protection benefit is lost. Okay. The costs are also quite high for patents. We'll come to a slide in a minute about patent protection costs. Sometimes I hear people say, you know, why should I file patents? I can't afford to defend them. And you know, it is expensive to secure patents and to defend them. But it may be that you develop enough revenue or generate enough revenue to be able to afford to do that. Or you may end up licensing the IP rights to someone else that can do that. And so Zuru, with their Bunch of Balloons product, this product was developed by this person here, Josh Malone. So he's a father of 8, lives in Texas, and he filed an initial patent application that Zuru became the licensee to. Zuru was able to get this product into the market, generate a lot of revenue to be able to afford the patents and to be able to defend against them. And so recently they've won a court case in the States against Tally Brands, as seen on TV people, and were awarded over 30 million New Zealand dollars in damages because of patent infringement for a patent that we were involved with. Okay, that's Zuru. So what are the steps involved to secure patent and design protection? So I've got a slide, animated slide here. So for patent protection, usually the ball is started to roll by filing an initial patent application somewhere in the world at month 0. Optionally, we may do some searching prior to filing the patent to determine how novel and inventive the invention is, to determine whether the protection is going to be broad or very narrow, and perhaps then not worthwhile obtaining. Okay, once the initial application is filed, you've reserved the rights to file internationally, but it also starts the New Zealand patent process. Within 12 months from filing the provisional application, the complete specification needs to be filed, and that then gets examined by the Patent Office. After examination, and assuming successful examination, the patent will be granted, and this may take 2 to 3, maybe 4 years from filing the initial application. Once granted, the patent has 20 years protection, assuming that all the annuity fees are paid. At the 12-month stage, this is when typically patent applications are filed abroad, overseas, and commonly we use the PCT, the Patent Cooperation Treaty process for filing overseas. Most countries are a member of this process, and it allows the filing of a single patent application at the 12-month stage, and then at the end of 30 months, that's when applications in individual countries need to be filed. Okay. This delays the cost, in particular, of filing into individual countries and allows for companies to generate revenue to be able to afford those costs, or potentially to find licensees in other countries that want protection for the invention. And here are some examples of costs that you might encounter. This is a typical patent process. Sometimes the timeline is a little bit different. Okay, now we'll go through the registered design process. So that's very simple. It started by filing an initial application in New Zealand at month 0. Before that, you need to keep the invention confidential. Once it's been filed, both for patents and registered designs, once the application's been filed, you can then publish the invention. You don't have to wait till the invention is registered. It's the filing date that's critical. Okay. We can do an optional pre-filing search. The New Zealand application then goes into examination. 95% of the time, it flies through the examination process without too many objections. And then the design will be registered within 6 to 12 months. The filing of overseas, the term in New Zealand is 15 years from the application date. And filing overseas applications can be delayed for 6 months. So by filing in New Zealand at month 0, you've filed a design application and reserved the rights to file internationally for 6 months. Okay, but there is a need to then file into specific countries where you want the design protection. And here are the typical costs involved in filing designs. Okay. So topic 5, what are some other things that you need to discuss with the client or the business, if you're in-house, about intellectual property? A big consideration is freedom to operate. In other words, how do we know that this product or this process can be sold or made or used in particular countries in light of the IP rights of others? Okay, so this is all about infringement. Are you going to be infringing someone else's IP rights by selling this product? And there are other freedom to operate hurdles, such as regulatory requirements and maybe even contractual restraints. So this is an important point to discuss as well. If there is an infringement problem that's identified, if someone else has a patent for a concept that covers your product, then you either need to stop infringing, design around the patent protection or design protection, potentially negotiate a license. You might be able to challenge the IP rights. Maybe they're not valid. They've been granted by a patent office, but that doesn't not necessarily mean that the IP rights are valid. They might be challengeable. Carry on and hope for the best. You also need to check which countries the IP rights are valid for. So IP rights are territorial. If there is a patent for a product in the United States and the United States only, then a competing product can be used or sold or made in other parts of the world without infringing the US patent rights. Okay. Or you might wait for the IP rights to expire. And then there's the question of ownership. So who owns the invention? So usually it's the creator of the product that is the first owner, but that can be varied by contract or through operation of law. So it's important to go through the chain of title process to determine, well, who has the rights to file the patent, who has the rights to file a registered design. Are there any obligations to assign the IP rights to someone else? Have previous contracts been entered into with other parties that need to be considered? Could the IP have been developed by an employee during their previous employment, and maybe their previous employer is the rightful owner of the intellectual property rights? Okay, we're nearly at the end. I just quickly want to cover off the differences between copyright and registered designs, because this is often a question that comes up. So copyright in all parts of the world resides in 2D work such as music and film and books and software. In a handful of countries, including in New Zealand, copyright can also protect three-dimensional products, so it can stop the copying of product shape, which is pretty unusual. It's, like I say, just in New Zealand and a handful of other countries. So sometimes clients here in New Zealand say, well, we're not going to bother filing registered design protection here because we can rely on copyright. But if your clients are exporting to other parts of the world and they don't want someone else to copy the shape of their product, they shouldn't be relying on copyright because it doesn't exist in most countries. So in most countries, in order to protect the shape, the three-dimensional shape of a product, you have to file registered designs. The difficulty with copyright infringement is that you need to prove that copying has occurred. So if someone else makes a product that looks the same but independently creates the shape of the product without copying, there's no copyright infringement. Okay. Sometimes the chain of title and copyright can be problematic. So contracts need to exist between the designers of a product and the company that wants to own the copyright. Okay, here's a flowchart that we've developed. It might be very hard to see, but it's a flowchart where you plug in a new idea and then it helps you identify which forms of IP rights might be applicable. So if you're interested in getting a copy of this flowchart, just email marketing@ajpark.com and we can send that out to you. Okay, so hopefully you found this webinar useful. We'll turn to some more questions in a minute, but as you'll have gathered, we're here to help. If you're in private practice and not familiar with intellectual property laws, hopefully we've given you enough to be able to have initial meetings with your clients to discuss patents and registered designs. But as I mentioned, we've got a team of experts here in over 60 areas of technology, and we can help you with patent protection, registered design protection, and IP enforcement, etc. Yeah, okay. So we'll have a look at some questions. So the question is, if an invention has been disclosed in breach of an NDA, does it still meet the requirements of novelty? Yeah, so that's going to depend on the country, but generally if an invention has been stolen and then is commercialized by a competitor, or it's put online and it becomes very widely known, it's very hard to recover its status of being confidential. Yes, there has been a breach of contract by breaching the NDA, but the invention has left the cone of silence. And for most countries, that's going to be detrimental to then filing patents. So if you are going to enter into NDAs with other people, with other parties, do your due diligence. You want to make sure that these people, whilst they're signing an NDA, can also be trusted. They have procedures in place to ensure that they and their employees do keep information confidential. Okay. So the question is, I think I've recently heard that Lego lost design protection in Europe. on the basis that the brick that they had protected by a patent, and that it was also protected by designs. Okay, so so registered designs expire after 15 to 25 years. So some of the design protection that we're talking about may have expired naturally. In some countries, products that are purely functional or very functional can also not be protected by way of registered designs. And so in Europe at the moment, we're seeing cases coming out where products that have got a reasonable amount of functionality to them and that are being protected by registered designs are losing that registered design protection. But it does depend on the country that we're talking about. It varies from country to country, that particular aspect. Okay, and then the question goes on to say, has Lego been unfairly double dipping its monopoly rights? What are your thoughts on this? Yeah, so I mean, a lot of products are eligible for multiple forms of intellectual property rights, and patents and registered designs have an expiry date. So their value tends to go down towards the end of the life of the patent. But by then, other intellectual property rights, such as brand protection, trademarks, start to increase in value because the product's been sold year after year, protected by patents and designs to stop someone from making a copy product or copying the concept. That allows for the brand owner or the company that owns the IP rights to really invest in the brand protection. And then trademark protection starts to take over. For example, Panadol is, a brand of painkiller that people recognize, that people trust. The product itself has no patent protection anymore, but when you're going to the chemist and you see a range of painkillers on the shelf, you tend to go for Panadol, at least here in New Zealand, because you know the brand, you trust it, and that's a good example of where the brand protection is taken over. I'm not sure if you'd consider it double dipping. It's just using intellectual property rights in a very strategic way. Okay. All right. Well, I think that's the end of the questions. Yeah, hopefully you found this useful. Anyone that's interested in the flowchart, drop marketing an email. Also, if you haven't indicated when you registered for this that you needed CPD points and a CPD certificate, then please email marketing@ajpark.com. And towards the end of the week, we will send out the certificates of attendance. Okay. All right. Okay. That's the end of the presentation. Thank you very much.